Hi there, I'm Savannah Mexto with Manor Law Group, welcoming you to another Webinar Wednesday with esteemed estate planning and elder law attorney, Bob Manor. Let's face it, the average family today is much different than the average family of the past. But what should today's modern families consider when planning for and protecting their futures? Attorney Bob Manor will be answering this question soon. But before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have just a general question during today's presentation, we encourage you to ask the question using the chat box. We will save time to review questions after the webinar, but if for some reason we don't get to your question, we'll contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent out later this week so that you can share it with your family, with your friends, or with anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Manor Law Group have to say? First, note that we are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. In fact, he's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. With that, I would like to welcome attorney Bob Manor.
All right, so this is a really interesting topic here. And so when we talk about estate planning for the modern family, one of the things, obviously, we're going to be needing estate planning for every family. And we have a number of webinars and presentations that are available on our website that go through some of the basics of estate planning that we all need, and some of the basics of what I call the lifetime documents, what you need during your lifetime, and then some of the more comprehensive documents and the differences between wills and trusts and things like that. But today we wanted to kind of talk about some of the unique situations that are not really all that unique, frankly, that they're actually very common. And we wanted to talk about them from the standpoint of people will often just imagine that they should have the same estate planning that they had, that their parents had or their grandparents had, or things like that. And often it just isn't going to work because of the unique situation. Sometimes, honestly, it's the law hasn't caught up with society. The law frequently, especially when it comes to estate planning and those types of things, is many times it's based on traditions and laws that are 500 or 1,000 years old. A lot of our estate planning law comes from sort of English law, and coming from the 1500s and things like that. There are a few things that were kind of quirks in the law that just recently are no longer part of the law, like a dower interest. If you ever heard of a dowry or a dower, that was actually Michigan law until recently, that a wife owned a certain percentage of her husband's real estate, and regardless of what the deed said. That was unusual that it was just the wife and not the husband, but that came from English law from 500 years ago. And so some of those things are pretty interesting. Now, in Michigan, dower interests have been abolished just recently, actually. And so that's just an example of where the law doesn't always catch up with the way society or things are going. So I have some examples here of things that we have to make sure that we have somewhat specific planning for, that we've really thought through. And one of the real important things about estate planning is that we're not just planning for if everything stays exactly the same. In fact, we know for fact that things will not stay exactly the same. We know that somebody's going to die, and that we don't know which, if we're going to die in what order. And we don't know, we know that somebody's going to die, and then the other person, if it's a couple, they're going to die at some later point. And so one of the things that we're often talking about is things like, okay, well, I want my partner to have access to everything that we have jointly. Of course, I mean, even if it's considered mine or my partner's or whatever, we want them, if I died suddenly, I want my partner to have access to all of that. But then in many cases, the situation is, but what if what happens when they die and they didn't spend all the money? What if there's money left over? What if there's assets left over? What do we want then? And often the answer is, well, I wouldn't want it to go to my partner's parents. I wouldn't want it to go to my partner's children, maybe. I wouldn't want it to go to my partner's siblings. I might not even like her siblings. I might not like their kids. And the idea behind this is that we don't think often beyond the initial. Okay, if I die, I want everything to go to my partner. Great. What next? And so what estate plan can do is kind of think through those things and say, okay, we often have very hurt feelings and have things go in a direction that was never intended, and that really goes in a direction that would be offensive to the person that that died had because we didn't really think through those things. And honestly, I'm going to be truthful with you that a lot of attorneys don't always think through those things. So certainly if you go to a website and download a form from LegalZoom.com, they're not thinking of the generational planning or the what next. It's just, well, if I die tomorrow. Well, you're probably not going to die tomorrow. And things are going to change between now and 20 years from now. And what happens after you die? What's the next step after that? And the forms that you download aren't going to do that. But I'm going to be honest with you, a lot of attorneys don't even think of it. A lot of attorneys just kind of think of it from saying, okay, well, if you die tomorrow, you're all set. The reality is you're not going to die tomorrow. And even if you did die tomorrow, what happens after that? What happens if your partner dies 5 years after that? Well, what happens to all of everything that you worked so hard for? Do you have children? Are your children going to be included in that? Well, if everything goes to your partner, your children might not be included in that, because the 5 years that between your death and their death, they even if they haven't spent the money, even if they haven't depleted the assets, the standard is if your partner's children are not, they're not joint. It's not your children are not your partner's children. Then they are. It's the default is going to be your kids will not receive those assets, and so that's the default. So you die, you leave everything to your partner. You have children, but your partner is not their parent. When your partner dies, your kids aren't going to get anything unless we do estate planning. So that's the overall concept here, is we really have to think through these things and not just the immediate and the obvious and things that often people will do, like a ladybird deed or a quit claim deed or adding beneficiary designations to things. Those aren't going to work. So a lot of people say, oh, I'm just going to put a beneficiary on that. I have beneficiaries on my life insurance. Guess what? That's not going to work, because what that's going to say is I'm listing my partner as the person that's going to receive these assets. If I die, they'll get the life insurance proceeds. Okay, well, what if it's $150,000 and they don't spend that $150,000? What if after your partner dies, that $150,000 is still there and maybe even grew a little bit? Where would you want that to go next? Because I can tell you, if your children are not your partner's children, your children will not get the benefit of that life insurance if you just have your spouse or your partner listed as a beneficiary. So obviously this makes it very clear in what I call blended families, that each part of the each husband and wife or each couple, they have their own children, or only one has children, or it's his kids and her kids kind of a thing, what we call blended families. So often, almost all the time, when we meet with blended families and they come in and they have a will. So there's two issues that I have. One is sometimes their wills don't match up. They don't match. But what it does say almost always is, when I die, everything goes to my spouse. And then it says, and then if I don't have a spouse, as my spouse dies first, everything goes to my kids and not their kids. I see this in all the time in blended family. They come in with their wills. Well, what does that mean? So if each of those, in other words, they don't match up, because it says, if my spouse isn't alive when I die, it's going to go to my kids and not their kids. That's what you would normally think. That's, intuitively they say, okay, well, that makes sense. I came into the marriage with certain assets, things like that. I want my assets to go to my kids. And so you say, well, that's what my will should say. The problem with that is that what we're doing basically when we have wills that say, and our partner's kids are not our kids, and their kids are not, my kids are not my partner's kids. What we're doing is we're saying, I'm going to roll the dice, and whoever lives longest wins. In other words, whoever lives longest, their kids get everything. Because what your will says is, I'm leaving everything to my spouse. I'm leaving everything to my spouse. And so when you die, everything goes to the spouse. When the spouse dies, everything goes to their kids, and your kids get cut out completely. This happens all the time. The second issue, and this is actually lesser of an issue than people think it is your spouse, you leave everything to your spouse, and then your spouse intentionally cuts out your kids. I think most of the time when this happens, the kids that got caught out think this is where the concept, the Disney concept of the evil stepmother comes in, right? Because I think most of the time they just assume that they intentionally left out the children of their spouse, when I think a lot of times it's because they didn't understand the operation of law and what is going to happen by operation of law, and sometimes by operation of the will that was poorly written, frankly. And so, but sometimes it is intentional. Sometimes it is, hey, my spouse died when we were together. I said that everything was going to be split equally between all of the kids, but after my spouse dies, I'm going to change it and have it all go to my kids. That is pretty common, but honestly, it's more common that we just haven't done proper planning. So honestly, even the concept of having it go through the will is problematic, because if you have a will, when does the will take effect? After you die. And not only after you die, but after you die and probate says it takes effect. It goes in, we have to go through a court process to activate that will. And so one of the things that you really can't do very well with a will is set it up so that we have planning for more than one death. And so typically in a blended family situation, we're really going to need a trust, and maybe two trusts, maybe a trust for each spouse, or maybe a joint trust. Sometimes we can do a blended family situation, have it be a joint trust. But one of the things that we have to specify is, yes, well, I'm leaving everything for my spouse when I die. Whatever they don't need, whatever they don't use, is going to go equally to both sets of kids, or this portion is going to go to my kids and this portion is going to go to their kids, or whatever. And we have to have that laid out in the trust, and we have to have restrictions on the spouse being able to change that, not only so that we don't end up having it be by accident that we're disinheriting the children of the first spouse to die, but secondly, because we're we don't want to give the opportunity or the temptation to the surviving spouse to cut out the kids of the first spouse to die. It gets even more complicated, and we're seeing this very frequently of unmarried couples. I have couples that I do planning for that they've been together for 30 years or more, but they never got married. And so we have unmarried couples, and there's a whole bunch of reasons why people stay unmarried, and that sometimes they have financial reasons, sometimes they have insurance reasons, sometimes they have reasons regarding Social Security or Medicare or those types of things. Sometimes they just have their own personal reasons why they never got married, but they've been together for 30 years. And so the idea of unmarried couples is all the things that we said about the blended families, that all applies to unmarried couples. In fact, everything we said about blended families applies to almost everything on this list. Okay, but there is additional complications with unmarried couples. Guess what? You're unmarried. You're not related when it comes to healthcare issues. You might not be allowed into the hospital room. You're certainly not allowed to make decisions on their behalf. if they're in a coma, or if they're, unless you have legal documents, and this is the answer for all of this, proper, well thought out legal documents that don't come from one of two sources, either a form that you found that you filled out. I can guarantee any form that you fill out is not going to be able to deal with the nuances associated with this, number one. Or, frankly, and I'm going to say this bluntly, attorneys who just kind of put something in front of you and just say, okay, you want a will, here's your will, sign here. In other words, it's not a somewhat of a longer process of thinking it through, of actually discussing these issues, kind of slowing down that process. A lot of clients would like that. They come in and they say, okay, where do I sign? And I say, hold on, we just met. I'm not having you sign anything until we go through a process of making sure that we've gone through this consultation, thought about these issues, made intentional decisions with regard to these issues, and the documents appropriately reflect not only what is what you want, but what you want based on changing circumstances that are guaranteed to happen in the future. And that's not something where you come in and say, okay, I just want my spouse to be the person that would make decisions for me, and everything goes to my spouse and then my kids. Okay, can you have that written up for me? Yeah, I can have that here, come back in a week or a day and you'll sign this. That's not what I call estate planning. That's filling in forms. That's being a stenographer where they write down, your thoughts. That's not estate planning because you haven't really thought through these issues. We haven't thought through all of the consequences, all of the circumstances. And with unmarried couples, and that's the same thing with the LGBTQIA community, is that if you're not married, now obviously that those rules have changed with regard to same-sex marriages and things like that. But traditionally, when they didn't allow same-sex marriage, it was the same thing that we had with unmarried couples, where we better have very strong legal documents that allow that waive the medical privacy, that allow me to be in the hospital room, that allow me to be able to make decisions for my partner, or be able to at least be involved in and be present with my partner when health issues come up, or being able to make sure that we can access finances to pay bills and make legal decisions and those types of things. We can certainly do that, but it wasn't automatic. There's certain rights that come along with marriage, okay? So if it's technically a marriage, then the law implies certain things about the spouses being able to be present. You're considered a relative at that point. You're considered related. There's certain privileges that come along with being related. But if you're technically not related because you're unmarried, then we need legal documents that are going to supplement these understandings and make sure that you have access, that you have the waiver of some of the privacy rules, and frankly just authority to be able to be in the room, to ask questions to the doctor, to be able to make decisions if that's appropriate for the partnership with the couple. Okay, so let's talk about a couple of these other things. Stepchildren. We kind of talked about this a little bit with the blended family, but really we want to think about this a little bit differently too, because sometimes we really haven't thought through these issues. And so we'll sometimes see that you can see whether the whether the couple sees it in each other or not. As an outsider sitting down with the couple, I can see an animosity with one or both of the couple, people in the couple, animosity towards their partner's children, or I see an ambivalence towards their partner's children. And then when we get to the issue of saying, okay, we should probably put something in here that provides some protection so that we don't just change everything. Whoever dies first, the surviving partner, everything gets changed and disinherits those children. And the first answer in almost every case is, oh, we're just going to trust each other. Two problems with that. One is, as an outsider, I can see when you're immersed in a couple, sometimes you might not see the things that I can, as a trained somebody that's been doing and meeting with couples and doing this sort of counseling. They always say attorney and counselor at law. There's a big part of the counselor at law part of it, and me being sort of a trained counselor, I can see the writing on the wall that maybe the couple that are very much in love and they really care about each other and they just can't see what appears to be something that seems to indicate that they might cut out the children. But the second thing is maybe that's not it. Maybe it's not because the person is going to intentionally cut out the kids, your kids. Maybe it's that as we get older, sometimes we get dependent on caregivers, we get dependent on others. Sometimes we're influenced with age. And I'm not trying to be ageist here. I'm just being realistic about there's a certain element of age where we are, and this is why you see scammers often going after the elderly. There is a certain element of age where many of us as we age get more vulnerable. Now, that's not true of everybody. And I don't like it when even the laws that are created that says, well, somebody over age 60 or over age 80 is a vulnerable adult. I don't like those laws because that's not really true. But there is a certain element that as we age, many of us become a little bit more vulnerable, a little bit more susceptible to influence or misdirection. And so we might say, oh, I trust my partner. Well, what if they live another 30 years after you? Is there going to be someone that's going to come along that's going to influence them, push them in the wrong direction? A caregiver that says, well, if I'm caring about you every day, where are they? Why don't you just leave everything to me? So it's just better to build in these protections, especially for blended families, for unmarried couples, but when we want to have some protections for the stepchildren. We're going to talk in a bit about, especially when there's a particular need by the children or stepchildren. Maybe there's somebody with special needs. Maybe they have things that we need to make sure we have extra protections for them. As we were talking about modern families, one of the things that came up was the idea that sometimes we're raising children that are not our children. So we'll frequently see, we'll have people come in and I'll say, well, how many kids do you have? Well, we have 4, but we count 5. And I say, okay, give me more information. Well, 4 are natural children, and then we raised our grandchild. So they lived with us as if they were one of our children. Our daughter wasn't able to care for them, or our daughter died, whatever it is, or our son, whatever it is. And so, or sometimes I have families that we work with, and they raised the neighbor. In other words, it's the best friend's kid that they stepped up, and there was some reason why they're the best friend, or even, there's just lots of situations where people are raising children that are not their own. And I'm not talking about adopted, because once you're adopted, the law treats you the same as if you're a naturally born child. Adopted or natural born is the same to the law. Once you're adopted, you have all the legal rights of a natural born child. And so, but what about those that aren't adopted, that aren't formally adopted? So it could even be foster children. I've had lots of families that they say, well, we want to make these special provisions for, we had 20 foster children through the years, but we want to make special provisions for these 2. These 2 were the ones that really felt like they were part of our family. They come over at Christmas, they're like a child to us, even though they might not legally be our child. Or, maybe there's not even any formal arrangement. We see this all the time where it's, this person you're raising a child, but it's not your child, and it's not maybe even related to you, and there's never been a formal foster child type of a thing. There's never been a formal court process. It's just that you've raised someone else's child. And we need to make special provisions for that, because they're not going to be, in fact, if you look at any of the form documents that are out there, so you download some form from LegalZoom, or frankly even go through an attorney that just kind of breezed through things, the standard language in most wills, most trusts, most of these documents it specifically excludes anyone who's not a natural or adopted child. So it excludes stepchildren, excludes anyone else. So we may have it in our mind, well, this is our child. We treat this like our child. But unless you specifically change your will, you change your legal document to take that language out or to tweak that language, you may even identify that person, but the language of the trust says, or the language of the will says, I specifically exclude anybody who's not my natural adopted child. So you got to be careful about that because it could be in the fine print. And sometimes I've seen lawyers draft documents like that create this conflict within the document that says I'm excluding everybody else, and then somewhere else it says, but I want to provide for this person. So now what do we do? Because the document itself is internally in conflict. So we just have to be careful about that. And you want to make sure that your lawyer, first of all, that you're not using some form document, because I guarantee the form documents are going to have that kind of language in there. And secondly, that the lawyer is actually taking the time to analyze, to look at the circumstances and draft based on what your needs are, write the documents based on what your circumstances are, rather than some kind of form boilerplate thing that they're putting together, especially with any of these situations that are special here. So what about the LGBTQIA community? Well, this is obviously a little bit different now than it was a few years ago, because it was really important a few years ago. We had some families that we worked with that they'd been together for 30 years. They were, for all intents and purposes, a married couple, and yet the law did not treat it that way. And so it was very important that we have a healthcare power of attorney, a HIPAA waiver, a financial power of attorney, a patient advocate form, just so that you could do the normal things that a couple would do, do the normal things that a family could do. You'd be able to visit each other in the hospital. You'd be able to, act as a couple and not be excluded or discriminated against. And so it was so important to have those documents in place. Well, now we do have same-sex marriage, and so that is less of a concern. But the same things do kind of apply, because, okay, so sometimes even, in a family, okay, well, have we formally, let's say we have children, and have both partners formally adopted, or, one might be a biological mother or even a biological father, and has the other partner formally adopted. Even if you're married, that's probably going to work, but we got to think about these things. We got to make sure that this is lined up properly. Are they legally both of your children or not? That's going to be very important. Decision making with regard to be treated as a married couple. Property rights. There are certain property rights that are where there's special or extra protections for a married couple that don't exist with two non-married people owning property together. They call it tenants by the entirety. Well, we want to make sure that we're engaging that tenants by the entirety, and we have those protections built in under any variety of circumstances. Well, the bottom line is, it comes down to this, is we really have to think through these things. This is not a fill-in-the-blank boilerplate. Frankly, I think nobody should have that fill-in-the-blank boilerplate stuff. We should be able to have a conversation about the circumstances, what if things change, what happens over time, and really be thinking through all of these things. Often what we're talking about are some of the most important things in life, like our health and our money and everything we've worked hard for, and our family. And a lot of people really feel like they can just do fill in the blank planning. Well, why wouldn't you spend a little bit of time talking about it? Why wouldn't you spend a little bit more time making sure we've thought through and really made intentional decisions about this, rather than say, I don't want to sit down with a lawyer, I don't want to, just put something in front of me and I'll sign it. Boy, that seems like a really not an ideal decision, when it really is some of the most important things in life: family, health, making sure that everything that we've worked for our entire life savings, is planned for properly, and that if I get sick, that it's going to be managed properly. If I die, that it's going to go where it's supposed to go and not misused or misappropriated. These are all just very important things. Another one that it's obviously extremely common is the single parent family. And so there's a number of things that we've talked about that are going to be relevant to the single parent family, but there's one in particular that I wanted to bring up. And so often with a single parent, we just assume, look, if I die, pretty good chance if we have minor children, the court is going to have the other parent be, they would be they would have full custody, the other parent, except in circumstances where it's been proven that they're unfit or whatever. Kind of the standard and what your expectation would be, hey, if I'm gone, my expectation would be that the other parent is proud. The court's going to just, make that initial assumption if the other parent's willing. And that's what it is. And so you can't write a will that is going to specifically say, well, I don't want their dad raising them. If their dad's willing and able and hasn't done anything horrible, and you can't, doesn't matter what your custody agreement is. If you die, they're probably going to go to the dad. However, what if the dad dies too? What if the mom dies too? What if both parents die? And what if your will doesn't say anything about who's going to raise the kids? And your ex-spouse's will says it's going to be raised by my parents. The child is going to be raised by my parents. And your thought is, in no way do I ever want my children raised by my ex-spouse's parents. They're the worst people in the world. They're part of the why we got divorced in the first, whatever it is. Or maybe they're your ex-spouse's sister, or your ex-spouse's brother, or whoever it is. You say, I want to make sure that doesn't happen. Well, guess what? If their document says who they want to raise the kids and yours doesn't, so I would strongly recommend for single parents that we specify, hey, in the event that I'm gone, yes, it's probably going to go to my ex-spouses if they're willing and able to raise the kids or take custody. But in the event that we're both gone, I definitely want it to be my sister. I definitely want it to be my parents and not their parents. Things like that. Those are important things to specify, because if their document specifies it and yours doesn't, it could definitely go in the wrong direction. You have some influence on making sure that they're going to go and be raised by people that are going to care about them and take care of them and things like that. Something we've seen recently a lot, it's actually been a pretty common thing we've seen recently, especially with older folks and especially with folks that we've helped deal with long-term care issues. So one of the parts of our practice is we help people that are facing a long-term care need. Often it's going to be somebody with dementia or Alzheimer's or any of the different types of dementias, and they need care. They need round-the-clock care, frankly. And round-the-clock care can be extremely expensive. And we find resources and government benefits that'll help pay for that care. That's one of the things that we do. And so what we've seen a lot lately is someone coming to us and we, start asking about their family, and it turns out that they're married, legally still married, but they're separated, and they have been separated for 20 years, for 30 years. They just never formally got divorced. Well, that's going to make a difference, and we've got to make sure that we have planning. And there are what's called spousal elections or spousal rights or family allowances that, because you're formally still married, the person that you really have been separated from for 20 years, 30 years, whatever, still has rights to a percentage of your assets. They can, they call it elect against the will or request the family allowances, and your spouse can get a percentage, and often a pretty good percentage of your estate, because you're not formally divorced. And so when it comes to healthcare issues, when it comes to the estate settlement, all of these things, if we know that and we say, okay, there's absolutely no reason why they should receive a share of my estate. We've had separate houses, we have separate assets, we've kept everything separate, we're just formally still married. We're going to need to do legal planning to make it, to make it very clear what the options are, and make it very clear that they're not entitled to spousal elections and things like that. And there's ways to do it. It's we have to make sure that the default is not going to happen. The default is they do have spousal elections, they do have marital rights, and so we're going to have to work against those and plan against those. And then the last one on here that's really important is, special needs couples and special needs children. So when we have special needs, meaning that there is some divergent physical elements or developmental or cognitive or like Downs or autism or any of these factors. One of the things in particular that we have to think about is whether or not we have either the person themselves or the children of the couple that are entitled to or are receiving any form of government benefits or disability benefits, whether it's Medicare, whether it's disability, whether it's aid to dependent children, whether it's Medicaid. All of these things are going to have their own set of rules. And if you just leave them as a beneficiary, if you leave them as an heir of the estate, they're often going to lose their benefits. Well, we really don't want to, you're trying to be nice and leave something to your grandchild, trying to be nice and leave something to your nephew. You produced a child together and you're trying to leave something to your own child, and you really don't want them to lose their medical benefits because of it, because you left something for them that's going to intended to improve their life and actually hurt them. So I have heard this way too often of even lawyers say, well, we'll just disinherit that person because they have special needs. That's not the answer. That's offensive, frankly, that is the advice that people are giving out to say, well, we'll just disinherit that person because they have disability, because they have Medicare, because they have Medicaid. We're just going to disinherit them. No, absolutely not. There are all types of options with regard to ABLE accounts, with regard to special needs trust. There's different types of special needs trust. Sometimes I use the term special needs trust and people flinch and they say, well, no, I don't want a special needs trust because I heard that if special needs trust, if the person doesn't spend the money, if there's money left over when they die, the government gets that money. That is one type of special needs trust. It's not every type of special needs trust. There are first party special needs trust, there's third party special needs trust, there's pooled trust. There's a number of options where if they didn't need the money, if they didn't use the money, then you get to direct where it goes next, whether it goes to your other children or to other families or to a charity or whatever it is, that it's not just going to automatically go to the government. There are certain types of trusts which are called payback trusts, which are that would go to the government if the government actually spent any money on Medicare or Medicaid or other benefits. And so we've got to be very careful on that. And it's not overly difficult or overly complicated planning. Yes, we should do it right. Yes, there's some steps we have to follow, but it is significantly better than saying, well, because this person has special needs, they have unique abilities or limited cognitive abilities or things like that, that we're going to disinherit them because we don't want them to lose their benefits. That's absolutely not the answer. There's a very clear and straightforward answer to do planning that's going to make sure that they get to continue they're getting their benefits and they get to continue to get the benefit of their inheritance. To be clear, the money will not go in their name directly. It'll stay into a trust for them that's going to have to be managed by someone else or a third party or a company or an entity or something like that. But that's much better than either having them lose their benefits or having them lose their inheritance because of their special needs. So, oops, I went the wrong direction here. So just to recap here, in all of the situations I've named above, beneficiary designations won't work. This is the most common thing people just say, I don't really know if I need a will or a trust. I'm just going to use beneficiary designations. I'm going to add their name to the account. With all of the things I mentioned above, all of the modern family type of things, that beneficiary designations absolutely will not work because it will not serve the long-term purpose that you're trying to accomplish. You absolutely need an estate plan. If we have any of these family situations that we've named here, you absolutely need an estate plan. And frankly, in most cases, you're going to need a revocable trust, What is a revocable trust? It's just a set of rules. It's a contract that you set up that says, here's how I want my stuff to go when I'm alive and well, if I become incapacitated, and after I die. And you set out a series of rules that doesn't involve a court, that is, keeps things sort of in the family or in the close connections that you have, and can lay out the rules that are going to not just be for, one iteration or one generation, but can actually lay out the rules that say, well, I want it to go to my partner, but when my partner's done with it and they didn't, if they, you didn't use it all up, then it's going to go over here. You can do that with the trust. You can't do that with the will. You absolutely can't do that with beneficiary designations. It probably need a trust. That was my next point. A basic trust likely is insufficient. A will is likely insufficient. And then we might want to consider co-trustees after the death of the first spouse. This is true for everybody, especially as we're getting up in age and we're getting older, and we had our spouse as our co-trustee, and that could act on our behalf if we got sick or just out of convenience. Sometimes if we have a trusted person that we would want to take over if we got sick, or we'd want them to take over after we die, maybe we put them in place before we get sick and before we die, only because it'll just be more convenient for them when they're called upon, when the time comes. So we'll often do that, especially on the death of a spouse. We say, okay, maybe consider bringing up your co-trustee and having them be co-trustee now, your successor trustee, having them be co-trustee now, just so they're in place when the next thing happens, when you get sick, when you become incapacitated, when you die, they're already in place. We don't have to trigger anything to make them take over. And then, of course, there's always the issue of planning for care, and it becomes very, important, especially, when we have different family situations and different couple arrangements. Planning for your children, we kind of talked about that. So we're going to take a look and see whether we have any questions here, and then Savannah's going to come on and actually tell you how to get your questions asked, whether it's now or that you'll be able to do it by just contacting our office. We have a method for you to be in touch with our office and get initial contact with us as convenient as we can make it here. So if you have questions, Savannah will kind of talk you through that. And then secondly, think about maybe updating your planning. Think about taking a look and maybe coming in for a consultation to say, okay, I want to make sure that this isn't just boilerplate. I want to make sure that we're actually thinking through, how life can change in the future, and what if we die in the wrong order, and what if circumstances change. We know just in the last few years with the COVID pandemic and all of that, life can change pretty darn dramatically in unexpected ways that we never could have perceived. And so this is just an opportunity to say, okay, I really want to make sure that this is well thought through and intentional, and we didn't just use beneficiary designations because we thought that was going to be easier. We didn't just kind of sign a form, whether it was provided to us by an attorney or otherwise, but we really were intentional about making sure that we've done, planning that's going to be best for ourselves and for our loved ones. So, Savannah, you want to kind of take over and give them some instructions?
Yes, absolutely. So as Bob mentioned, we do have a couple of easy ways for you to get in touch with our team. If you look in the chat box, I have put our phone number, which this is just our 1-800 number, 1-800-990-6030. That's toll free, of course. You can give us a call there. Also in the chat, I have put a link. When you click this link, it will take you to a calendar. And from there, you'll be able to choose a day and a time when a member of our team will call you. So maybe you're listening to this webinar right now and you're like, oh, I would love to connect with them, but I'm busy. Today's not today. I'm on the road or I'm at work or whatever it is. Go ahead and click that link and schedule a time for when it will work around your schedule. And we're more than happy to do that. I'm also sending an email. You may already have it. You might get it in a minute or so. But that email will also have that link and our phone number. And then again, you'll just be able to contact us at a time that's good for you. And we can contact you at a time that's good for you as well. The replay for this webinar will be sent out later this week. So, as I mentioned earlier, you'll be able to share this, rewatch it, and then of course pass it along to someone who you think it could help. And that's it. Thank you so much for joining us today, and we look forward to seeing you again next time.